Less than 2 weeks ago, activist and Bersih 2.0 chairperson Maria Chin Abdullah was picked up by the police at her office in Petaling Jaya and locked up under solitary confinement. Now, this invoked dark and haunting memories of the controversial Internal Security Act 1960, a preventive detention law repealed by Prime Minister Najib Razak in September 2011. But now that the ISA is gone, why has Maria been thrown into similar circumstances? Enter its brother, the Security Offences Special Measures Act 2012, more commonly known as Sosma. So let's find out today 5 things you might not know about Sosma. When Prime Minister Najib announced the repeal of the ISA in 2011, he also announced that it would be replaced. Since Sosma's inception in 2012, it received fierce opposition and criticisms from the opposition. Sosma allowed for detention without trial and denial of access to legal representation, all under the same premise of the Internal Security Act, to allow the authorities to execute preventive arrests as a way to combat threats to national security such as acts of terrorism or organized crime. So what makes Sosma any different? The first difference of all is that Sosma is a procedural law while ISA is more of a substantive law. Substantive law explicitly defines what is not allowed as far as the law is concerned, as well as what's coming your way if you break it. Procedural law, on the other hand, focuses on the formal steps that need to be taken to carry out a list of rules and regulations. It is used in conjunction with substantive law and cannot stand on its own. The ISA is more substantive and specific. It deals with national security and pretty much can be used on its own. You threaten national security, you get locked up for 60 days and possibly another 2 years after that. It's that simple. Sosma, on the other hand, is where things get complicated. It is procedural and can only be used in connection with another statute. Take this example. Article 5.3 of the Federal Constitution guarantees the rights of a detainee to seek legal advice, while Section 117 of the Criminal Procedure Code caps a police detention on a detainee at 24 hours, following which they would need to get a remand order from a court to apply for an extension. A Sosma arrest can deny a detainee of some, if not all, of these rights by denying the detainee access to legal advice and his or her family for the first 48 hours of the arrest and detention for up to 28 days. Some parties have raised the question about whether Sosma is in direct violation of a basic principle of justice, where everyone under the law is innocent until proven guilty. There has also been an argument that Sosma is a more humane set of legislation when compared directly to the Internal Security Act. For one, it reduces the detention period from 60 days as outlined by the ISA by more than half to just 28 days. With the ISA, the detainee can be imprisoned for up to 2 years at the discretion of the Home Minister after the first 60 days of detention, and this 2 years can be renewed indefinitely. Sosma, on the other hand, gives the police the discretion to deny the detainee access to legal advice or meet with their families for the first 48 hours after the arrest. Sosma also has a no-bail policy. A possible outcome of this would result in a person being incarcerated for months on end pending a court hearing. Sosma, being procedural law, also does not clearly outline what will be construed as a threat to national security. For example, when former Batu Kawan UMNO Division Chief Khairuddin Abu Bakar and his lawyer Matthias Cheng went overseas to lodge reports against the controversial sovereign wealth fund One Malaysia Development Berhad or 1MDB, they were charged with committing an act that is detrimental to parliamentary democracy. If being incarcerated for months on end waiting for the courts to sort out your paperwork doesn't sound bad enough, remember that Sosma is procedural law. It is applied to Chapter 6, 6A and 6B of the Penal Code. These 3 chapters address crimes against the state, terrorism and organized crime. Sosma also applies to the Special Measures Against Terrorism in Foreign Countries Act. Some of these laws outline offences punishable by the death penalty. Therefore, if you are charged under Sosma, you could be sentenced to death. Human rights activists have used many of the same words they used on ISA on Sosma as well. They've called it draconian, cruel, authoritarian, and some have called it unconstitutional. Is it really unconstitutional though? Articles 9, 10, 13 and 15 of the Federal Constitution guarantee the right to personal property, freedom of movement, freedom of speech and freedom of association. However, further down that list is Article 149 that allows the Dewan Rakyat to pass special laws that do not conform to these provisions in the interest of counter-terrorism. The ISA and Sosma were both established under Article 149 of the Constitution. While Chief Justice Arifin Zakaria said that there were 110 cases related to Sosma heard in court in 2015 alone, could an end to this act be on the horizon? It very well could. The clause that grants the police to extend the detention period from 1 day to a maximum of 28 days has what's called a sunset clause, just like a self-destruct timer. If this is not renewed by the Dewan Rakyat every 5 years, it will automatically become null and void. Sosma is already 4 years old and the government is already planning to give it a new lease of life with a motion to renew provisions under the Act due to be tabled in the Parliament during the next Dewan Rakyat sitting in the March of 2017 before its due date in July 2017. That's what we know about Sosma. Do we need such a law to take on terrorism and threats to national security, especially with other statutes that provide for more extreme measures such as the National Security Council? Maybe after some debate in the Dewan Rakyat in March, we'll find the answer to that. Till next time, I'm Daniel Anthony for KiniTV, and this has been Quickiepedia.